Good evening, distinguished guests, ladies and gentlemen. We will be commencing this session shortly. I will now pass the floor to the director of the AIAC, Dato Mary Lim Tiam Swan, for the welcoming remarks.
Thanks, Bhavini. Good evening, distinguished guests, ladies and gentlemen. Thank you for braving that rain. I think for Malaysians, we love rain because under the Muslim calendar, it's all the Rahmat, which is good. For Chinese, wow, it's Chinese New Year very soon, and it's cleansing. I suppose I will have to go home and ask my son-in-law what is its significance under the Hindu calendar. I don't think it will be really any different. Rain is but nourishment and cleansing. Good evening and welcome. I always say this is a part and annex to the House of Arbitration. Ladies and gentlemen, even before the first month of 2025 is out, and just before we usher in the Chinese Lunar New Year of the snake, the AIAC is so proud to be accomplishing yet another milestone. And we simply could not have done this without each of your support, encouragement, and most of all, belief. And I am privileged to be part of this effort. A thank you to every one of you and to the team at the AIAC. I must immediately thank each one of them, from Firdaus to Shahir. I'm going to miss all my boys and girls, and I'll be crucified by them. But to the whole team at the AIAC, thank you. This milestone, ladies and gentlemen, is about mediation in criminal cases, innovative or unorthodox. It sounds almost heretical to even suggest or be associated with this very idea of mediation in the context of criminal justice, and more so by someone like me who spent over 28 years at the Attorney General's chambers. And just in case you are not familiar, the Attorney General is the public prosecutor in charge of everything to do with criminal justice. The suggestion of mediating in criminal cases appears relatively unorthodox, if not innovative. It is, or appears to be, uncharted waters in the seas of dispute resolution. Or is it actually not? Is the use of mediation in criminal cases, in fact, taking plea bargaining, victim compensation, and case management in criminal cases just a one or a few levels up? And if we do come round to, in fact, developing, adopting, and implementing mediation in criminal justice, will it in fact be extensive, applicable regardless the offense, be it of the person, property, or state? Can we mediate and compromise for serious crimes which currently invite corporal punishment? Or is it to be available only to petty thefts, assaults, and battery, where family and not others are involved? And if so, is that getting our values in the correct order of priority? And if, ladies and gentlemen, we are at the end of this evening's conclusions, recommend mediation in the final analysis, will it be to the law enforcers before the offense is a charge? Should it be available at all levels of the criminal justice system, from the stage of investigation, by the authorities to the trials and even appeals? Should judges themselves mediate, as we sometimes see our Malaysian judges do? And should they mediate with the defense and prosecution to offer information in confidence without fear of reprisal or breaches later at the trial? So many interesting questions, isn't it? And more. What else could have taken you through the rain away from your Chinese New Year's preparations? Unless, as I look around the room, you guys actually avoided those responsibilities to be in the room. Can mediation, ladies and gentlemen, truly find a place in criminal justice? Can it, in fact, complement or even reshape traditional methods of justice? Or are we, in fact, relearning our very own methods? After all, communities have been trying criminal justice as seen fit by the community, and it's not unusual to hear of passing the peace pipe even for what we today label as criminal wrongs. Can we balance the rights of victims, interests of society, and principles of justice, all the while introducing a more restorative, perhaps less adversarial approach to criminal matters? With Malaysia, you already using AI in sentencing in Sabah, whilst other jurisdictions deploy the use of sentencing councils, I actually don't see any reason why we shouldn't explore mediation in criminal justice. Personally, ladies and gentlemen, it's in fact heartwarming to be part of the era where other aspects of sentencing are now given better focus. Instead of the traditional objectives of punishment, deterrence, retribution, and that rehabilitation and protection are now to be made more holistic and not one-dimensional. That the interests of the public or community means more than society, victim, and other collateral innocence. That proportionality is a value justice. I guess we're all going to hear and find some answers to these poses from the experts or from those with the relevant expertise. For today to be really worth each of your while, you are encouraged to think critically, ask questions, regardless whether you've been representing the defense or prosecution. Do ask questions, ask them openly, be engaged with the materials and the thoughts that will be shared shortly. Your insights, your feedback, and shared experience are what will make this event truly valuable. And here at the AIAC and of course Malaysia, we have witnessed significant developments in the area of ADR, with mediation and arbitration increasingly becoming fixtures of civil law proceedings. So the growing importance of mediation in Malaysia is already very much under the effort of Shanti, who we are so proudly exported to Singapore to be part of the Singapore Convention on Mediation, exported for some very specific purpose and not to be returned to roots. So ladies and gentlemen, whether you're going to view mediation as a complementary tool or as a groundbreaking shift in legal criminal practice, the insights of these experts will help us gauge whether mediation is truly a step forward or a step away from established norms. Mediation in criminal cases will offer us an intriguing potential to transform the way we think about justice, from those elements that I talked about to something that is more holistic. I want to wish everyone the happy Lunar New Year. And may the two snakes, I think we're going to get two snakes this year, bring good health, prosperity, and happiness to each one of us. I want to single out a few friends whom I reached out just a few hours ago and who are in this room, starting with Chowie. Thank you so much for rounding up your whole cohorts. He needs to come up to find out what's on the plate. And Philip Pierre, who has been supporting AIAC for the longest time, he comes and he wants to know what's the next page. And of course, Dr. Jeff Yong, and so many more. So let's see, every one of you who's going to celebrate New Year, happy Lunar New Year. Thank you.
Thank you, Dato Mary. I would now like to invite our panel to join us on stage. Before we begin this session, I would briefly like to introduce our moderator, Ms Shanti Abraham. Shanti Abraham is a lawyer of nearly 30 years standing. She has an active corporate and dispute resolution legal practice in Kuala Lumpur. She is called to both the Malaysian and the Singaporean bars. Shanti is a mediator, arbitrator, and adjudicator empaneled by the AIAC and the current secretary of the Chartered Institute of Arbitrators Malaysian branch. Shanti is an international mediator with the Singapore International Mediation Center and AAA ICDR, principal mediator and trainer with the Singapore Mediation Center, and an empaneled mediator with the Malaysian International Mediation Center, BCAM, and other panels in Malaysia and beyond. She is committed to the development of the mediation landscape and advocates for mediation as a first considered step in disputes, whether complex or otherwise. She has helped to craft and manage the Malaysian COVID-19 mediation program and is part of the committee looking at revamping the Malaysian Mediation Act and ratifying the Singapore Convention on Mediation. She is also a member of the Pro Tem Committee for the AIAC Court of Arbitration. I now pass the floor to Ms. Shanti to commence this session.
Hear me? Yes, now I can hear myself. A very good evening, everyone. It is such a pleasure to see all of you, and this room is absolutely teeming with vibrant people this evening. Now, this particular event, firstly, it is a great pleasure for me to moderate the very first AIAC talk series for 2025, I was told. And I want to tell you a little story before I introduce the panel. Now, a week ago, this series was not in existence. There was a Bengkel, a workshop in the government had convened where AIAC's representatives, including Danish, Heather, and Bhavani, were attending, and we were looking at the revamp of the Malaysian Mediation Act. So for those of you in the room who may not be familiar, Malaysia's pride is that we actually had a Mediation Act from 2012. Right? If you didn't know that, we did. But it is time for that Mediation Act to get a little bit more grown up. And so we were having a workshop to examine and explore that. In that process, we were looking at the schedule. And if you were to look at the schedule, there are a list of actions which are excluded from the Mediation Act. So I will preempt you by telling you that injunctions, land administrator activities, specific performance, as well as criminal actions are excluded by the current Mediation Act. But because we are in the process of revamping it, now thought leadership is being invited to have that discussion. Now, our key speaker this morning is Mr. Pascal Comvalius, and Pascal lives in Netherlands. So during that Bengkel, the conversation somehow just naturally went to, shall we think about whether we should be excluding all criminal matters for the next Mediation Act? And so Pascal's name came up, and I mentioned his book, which is about mediating criminal cases. And there was a sense of fascination and surprise, particularly from our friends in the AG's chambers. Thank you so much. In AG's chambers. And it suddenly dawned on me that I had met Pascal in August, and he had mentioned that he was coming to Malaysia in January. So the stars were aligning, and the stars cannot align unless you have an institution like AIAC and people like Dato Mary Lim and Danish Chandran and Bhavani, who then said, if he's coming, we will host a talk. And this was Thursday. So at which point I thought I better check with Pascal whether he was going to continue with his trip to Malaysia. As it turned out, he was in Bangkok, enjoying yet another Asian country. And you are all here today, and I really want to ask you all to give a round of applause to AIAC for pulling this off. We have stunned Mr. Comvalius because of the turnaround time. And this, by the way, is what we call Malaysia Boleh. All right? Now, Pascal has got Indonesian blood, and he was talking to me about nasi putih and ikan bilis. So, you know, he is one of us as well. Now, on that note, so I wanted to just thank AIAC for this this wonderful event. Now, I'm not going to take any more time. I'm going to introduce you to our key speaker and then tell you a little bit about what we're going to be doing for the next hour or so. So Pascal Comvalius is an IMI certified mediator, a certified hostage crisis negotiator, and trusted counselor. He obtained his master's degree in communication, behavior, and credibility analysis. Pascal practices and teaches around the globe, where he specializes in criminal and family law mediation. He's a former member of the International Standards Executive Committee of the IMI and is the current chair of the IMI Appraisal Committee. He's also a visiting faculty member at the Maharashtra National Law University in Mumbai for the master's degree in mediation and conflict resolution. Pascal is the author of this innovative book, Mediation in Criminal Cases, and he is here to start the conversation in Malaysia about the potential of mediation in criminal cases. Now, together with Pascal, we have two stalwarts of our Malaysian bar. And I start by introducing Mr. Shannon Rajan on my left, who is a dispute resolution partner in Sanjay Mohan. He is head of the environmental and OSHA practice, and he also specializes in infrastructure, construction and engineering, aviation and regulatory compliance. He's a fellow of the CIARB, an arbitrator, an adjudicator, and a mediator who sits on the panel of several leading international arbitration institutions and mediation centers. He is a highly trained mediator who was part of the Harvard program on negotiation, mediation, and conflict management, and the Aranda series International Mediation Leaders Program. He is also an IMI certified mediation advocate, and he's the first one to ask me whether we could do mediation in criminal matters, and his focus was environmental law and OSHA, maybe 8 years ago. So this is all our roots and thought leadership from many years coming together. Now, on my right, we have Sangeet Kaur, someone who does not need any introduction, but I will introduce her anyway. Sangeet, the extraordinary criminal law practitioner in Malaysia, is a partner in Messrs. Karpal Singh and Co. She's a skilled litigator and a highly accomplished lawyer based in Malaysia. She has almost 2 decades of experience practicing law, where she has built a unique ability in both civil and criminal litigation. Now, with the extensive experience in defending criminal cases, including death penalty litigation, and a deep expertise in civil law, Sangeet seamlessly navigates the complexity of both domains. And over the years, she has practiced criminal law, specializing in defending clients in complex cases, including death penalty and drugs. Now, Sangeet is a member of the Drug Policy Program in Malaysia, which advocates for drug policy reform and aims to assist the government to introduce progressive drug policy reform in Malaysia. And she's a passionate advocate for diversity and inclusion within the legal profession and beyond. And as all of us know, she works tirelessly to promote equal access of justice to all. Thank you to Shannon and Sangeet, who also, without hesitation, agreed to be part of this magical panel. Please give them a round of applause. Now, pulling together a talk series like this with hours to spare, this team came about with the structure that we would like to map out for you today. We will kickstart with a conversation led by Pascal, where he will talk about his experience of mediation in criminal cases. And then we will be inviting Sangeet and Shannon to weigh in on possibilities in Malaysia for kickstarting this conversation on our turf. And I will then open up the time for questions from the audience. Let's make this a lively and warm conversation. This, by the way, is only the first of many conversations to come on this very interesting topic. So without further ado, it is my distinctive pleasure to invite Pascal to take the floor.
Thank you for that. Sorry, I'm a walker. I do not like to sit just behind the desk. Let me start first with a question to you. How successful are we in mediation in criminal cases in the Netherlands? How many end up with an agreement? What's the percentage you think? How it's just going to be solved so that the parties will have an agreement, a signed agreement. Yeah. If you're looking at mediation in criminal case, so that parties just agreed on certain just points and maybe even talk about compensation, we have a success rate of 90%, 90%. Which is extremely high. And because of these results, that's why also our government is funding us. But let me just start you to tell more just about the framework itself. How are we doing this just in the Netherlands? First of all, it's not replacing any juridical procedures. It's a process which is existing next to it. And who can just ask just for this mediation? Can be the victim, can be the offender, can be referred by the prosecutor, or even the judge or the higher court. And even by police just being referred. We want to start mediation in criminal cases as early in the process as possible. And by doing so, there is of course certain selection because we need to just make sure that parties want to mediate. So we have that selection just at the court by the mediation center, which is part of the court. And if they agree to mediate, then we will first have an intake. And there are two different just things. One of the different things, we're not only just doing it with one mediator, but with two mediators. First reason for that is security. But secondly, and I think that's even just more important, is the building rapport. That as a dancing partner, with someone you dance really good, and the other one you cannot dance that well. So there's just a highly chance to just have that cohesion just together. We are not looking at facts or when somebody is truthful or not. That's up to law enforcement. That's up to the court to decide. We're not doing just on fact finding. What we basically do is facilitating a conversation. A conversation of what happened and how do you want to move forward from that point. We start with the victim. Just have just a 1 hour intake. Just hear his or her side of the story. After that, we invite the offender and have that same conversation. During that time, it is possible to have your lawyer just being present. At the same time, if we're going to have the joint session, the joint conversation, we ideally do not want to have the lawyers just present. And most of the time they're even just even not. They come just at a later stage of the process. So by having just a conversation, we already can sense, okay, are these people even just able to and feel secure to sit in the room together? The crazy thing about it is that a lot of times they don't even know each other. They don't even remember what the other person looks like. Oh yeah, he was really tall, or no, she was. Oh yeah, she had like the color, or she was wearing a scarf. They don't even recall that most of the times. So you get different responses like, oh, I didn't expect you just to be this. But when we are going to that joint just conversation, that's always just the first minute, just a couple of minutes of tension. Because they see each other just for the first time, if they do not know each other. So we start to introduce by saying, as a mediator, hey, you're here just involved, and this is what binds you, just the incident. And you might just have perceived what happened differently than the other party, but just listen to each other. So we're going to have that conversation just together. The conversations go, and we're also just looking for, we're asking just the questions. Now, after that, we want to see, okay, what do you want to accomplish? What do you want to just happen? Could be compensation, could be an apology. A lot of times also, I just want to look that person in the eyes. And it's not that you can get away with anything. Like, okay, I'm just going to participate as an offender of this mediation. I'm going to jump through this hoop, and then I'll be fine. It's not. We tell them that even though if you participate in mediation, the court can look at it and say, well, this is a great agreement, but I still think it's important to punish you in whatever way. Or the court can say, well, this is so beautiful, like being solved. Why do we have to just have any say in? So the case gets dismissed. So we tell them just as well. And why mediation in a sense? Because we believe just in the 4 pillars. Yep. In the voluntariness. Well, you're forced in this situation, right? To have that just conversation, because what happened? Second is just confidential. So whatever just happened stays within the room. But if we notice that there are some threats are going, we breach that confidentiality. Because then we are witness of a potential criminal act. So we need to break that. Of course, the neutrality, or just, I would call it omnipartiality. We're there for everyone, to support everyone. And last but not least is the self-determination aspect. Who are we to decide what is justice? Yes, there are certain rules that for this offense, you get 2 years in jail, or you need to pay a certain fine. But people have their own standards of fairness. And if you just take that just into account, you really see that mediation will help. And it will help just the courts as well. Our own criminal acts or offenses just being used for mediation? No, definitely not. But look just at the real, just I give you just a real example, and we discussed this just before in the other room. We're all being young, I've been rebellious too. And at one point, this guy just grabs a bottle and he throws it just at a restaurant. Glass shatters. There are people eating on the other side. The restaurant owner happened to be a law enforcement officer. He's like, hey, well, I cannot tolerate it, so I'm going to press charges against him. He gets caught. But moreover, he says, I want to speak to him. I want to have a conversation. And to make him just see just the other side, what happened. Juvenile comes in with his parents, and they're having just this conversation. Of course, the guy says, well, it's only just almost, it was an empty bottle. It was nothing special. Until the restaurant owner asks, imagine that your parents would be eating on the other side or just sitting in that restaurant and getting the glass all over their food or just all the scratches on their head, in their face. How would you respond? For a minute, he went silent. Like, I would not like this. I did not realize that it could go really wrong. I would never want it to happen. For that, I apologize. And I'm willing, because yes, it's on camera. I threw that bottle. Of course, I'm going to compensate you for that, for those damages. The restaurant owner said, that's good. I'm really happy to hear. The parent said, we're not going to pay for it. You're going to work for it. You're going to work for it. We're not going to pay for what you've done. When this got solved, was the handshake. And I said, if you're just going to behave like this and pay everything, you're more than welcome to eat or even work at my restaurant. Should this be going just to court and go all the hoops and waiting? Just a thought. The other thing is, and that's a little bit more, when a car accident sometimes could be fatal without any intent. And what it is that when they were just talking just about with each other, the family of the victim who passed away and the offender were coming together, and the family said, "We forgive you. We forgive you for what you've done. You did not go intentionally go on the road and hit someone. Yes, you have to bear consequences, but we forgive you." The offender, when he heard it, he cried. Because that was the greatest gift, because he is like, I already have to live this my entire life that I kill someone without my action, right? So we see in that sense that mediation in criminal cases, only just by having that conversation is definitely just helping. It's empowering them, from victim and the offender, go back just into society. It's important just to have it just as at the early stage. And mediation in criminal cases is not the same as restorative justice. Restorative justice, if you look at the pure definition of restorative justice, is done after. It's just reintegrate because it's between the victim, offender, and the community, because the person has to go back into the community. But there are elements in mediation in criminal cases of restorative justice. You restore something. What we see as just as mediators is just having that pure conversation and coming together is crucial, is essential. You have to be on stepping toes. You have to be just ready, just really be aware, not missing one single beat. And be aware that it's still just a high conflict, could be a high conflict situation. That's why we have everything at the court. It's always nice to have cases at the court. People don't, if there are one or two places where people don't want to be, it's the court and in jail. So already just make them go there and say like, oh, how do you feel? How do you think? It's like, oh, I don't want to be here. Well, good. Already that mindset to have that. Oh, am I doing on time? 5 minutes, okay. Then I want to really just touch up on compensation, financial just compensation. We aim to have the whole compensation finalized before we send the agreement back to the court. Otherwise, the judge is going to be left with some sort of agreement. Okay, you're certain with all payment scheme. It's not closed. The case is not closed. It's still open. And who is going to guarantee that the full amount is going to be paid? Because that will trigger something else. So we choose, therefore, to have everything in that particular agreement. And that agreement is some sort of just a template, and we encourage the parties to confer with their lawyers. Lawyers, I believe, have a really valuable role in this case. We honor them in that sense, recognize them, and still, we're not legal advisors. It's up just to them just how to decide. Yes, we have this certain just standards. So the mediation agreement and the final just agreement goes back then to court, and then it's just going to the whole court process. So then it's out of control. As mediators, we're not working for the court, we're working with the court. So we're not part of the court system in that sense. When it comes to trainings, we need to just meet certain requirements. Continuous learning, education, it's important to keep on learning, to keep improving yourself. And last but not least is also having the discussion with your co-mediator. What went well, what went wrong, and how can you just improve? Because some cases along the line could just emotionally hit you. because it reminds you of something which happened just in your past, or in other cases which you have just seen. So it's important just to have that conversation after that too. Do I see it work in other countries? I've asked myself that many times. What I just explained is a framework, not the framework. So my hope is that you are able to apply it within your own jurisdiction. Are there modifications? Yes, there definitely will be. But give it a thought about how you all can lead as you are sitting in the room, as you can lead by example, and as you can see, you can give the satisfaction back to the parties. Thank you.
Thank you very much, Pascal, for that wonderful introduction to mediation in criminal law cases. And now I'm going to be turning to our Malaysian experts here to see where these concepts, this framework could potentially be explored and applied. Now we're going to kickstart with Sangeet, and please welcome her. The floor is yours, Sangeet.
Good afternoon, everyone. Shanti, thank you for having me. Thank you to AIAC for organizing this. It is indeed a very interesting topic, one that is not commonly spoken about within the criminal law circles. I wouldn't say it's the first time that this has been discussed. It has certainly been thought about, perhaps in the earlier years, but it's never taken off. Perhaps not seriously considered. Now, when Shanti approached me a few days ago, of course, I started thinking about how this would fit into our context, the Malaysian context. As Pascal said, it is a framework that perhaps could be adapted for our country. Now, I immediately thought this would be extremely useful to consider, especially in juvenile cases. I think that is where we really need to focus, because children should not be within the criminal justice system. And they are the ones who really should be diverted out of it at the earliest possible stage. Now, having said that, the criminal justice system in Malaysia and mediation, immediately what came to my mind was the potential conflict between mediation and the powers of the Attorney General, and the constitutionality of having or taking on board into our own hands the outcome of criminal matters for which sentences are statutorily provided for. This could, as we all know in Malaysia, the AG has the sole discretion to prosecute, to discontinue or to prosecute. It is entirely up to him, and we cannot have a situation in which mediation could result in circumventing, for example, prosecution. Criminal justice serves a public function as well. There is an element of deterrence, and in Malaysia, I suppose the more orthodox and conventional retributive position that we take, it is more between the offender and the state rather than the offender and the victim. So, for example, it is the state that will decide whether to prosecute or not. So if a victim lodges a police report and the police investigate but find no criminal element and decide to NFA the case, there's really nothing more he or she can do in terms of a criminal prosecution. Therefore, the victims, whatever they have gone through is not addressed. And that is why I say it is more between the offender and the state. But therefore, if we can if we end up having a mediation process that could essentially take us out of prosecution, that could lead to a number of problems which I feel need to be seriously considered to ensure that this process is constitutional. We cannot have a situation where the rule of law is undermined, or particularly where there are inconsistencies in the application of justice. As many of you would know, certain liberties have been constitutionally guaranteed, and that, for example, is the principle or the right to equality. That is equality of the law for the victim, but also the equality of the protection of the law. So I wouldn't want a situation where there are inconsistencies in sentencing that could lead to unequal treatment of certain offenders in the same category of offenses. You may have a situation where certain offenders can bargain their way out. And we wouldn't want public policy to be undermined in the context of people or the public taking the view that you can bargain your way out of a criminal offense. Having said that, now, given that constitutional framework, we do have certain provisions in our law, as was alluded to earlier, that could be a stepping stone towards this. And I think we have to be very careful and selective of the category of offenses and offenders that we are looking at and how this would be applied. We have the plea bargaining process that was introduced, I think maybe about 10, 12 years ago, if I'm not wrong, which allows the court essentially to engage the prosecution and the defense in a conversation as to what sentence is acceptable. There will be a conviction that is recorded either on a lower offense or a sentence that is agreed upon that is acceptable to the prosecution. So the prosecution also, in view of public policy, have to ensure that sentences are meted out in a proportionate manner. And that has to be considered as well. So perhaps we can think about an extension of plea bargaining towards mediation in criminal cases, which would involve the victim. I think that is the main difference between plea bargaining and mediation in criminal cases. Plea bargaining does not directly involve the victim. It involves only defense counsel and the prosecutor, while mediation would go many steps ahead and involve what the victim requires in order to move on. We do need to consider, in view of sentences that have been statutorily provided for, are we going to consider mediation that allows for a settlement outside those provided for sentences? Or, like plea bargaining, you have only that room to play with. For example, if there is a range of sentences between a fine and an imprisonment term of 0 to 5 years, and perhaps the prosecution is willing to say to you, in view of the facts and circumstances of this case, to us 3 years is acceptable, or 2, but that is still within the provided statutorily provided for sentence. Mediation may take us outside that ambit. So my immediate concern was, of course, the constitutionality of that and the consistency in the application of the law in this country for criminal offenses. I do feel, as I said at the beginning, that there are certain categories. We can talk about minor offenses, which certainly can be dealt with this way. It can still be constitutional if we have it interwoven with the AG's powers. It can still, and where juveniles are concerned, I think we certainly should be starting that conversation immediately. I think that's about it for me in the Malaysian context for now.
Thank you very much, Sangeet. Give a round of applause. So I've identified it, I summarized it as your 3 C's, basically constitutionality, consistency and the categories where this would apply. So these are the seeds we want to plant, and hopefully we will get some sprouting as we go forward. And now I hand the floor to Shannon to take us through another perspective or further perspective on where mediation might be able to work and might not.
Thank you, Shanti. Okay, so I'm going to have some caveats here before I start. I'm actually quite sleep deprived. So I've been working on my adjudication decision and it's due tomorrow. So my thoughts may not be as organized. But what I'm going to try and do is I'm going to start talking about why it's a no, why it could be a yes for mediations in certain circumstances. And I'm going to take you through the journey of my experience. Let me start off by saying, and Shanti was apt in pointing out, my first experience was in relation to an environmental matter in Malacca, and I walked up into the courts and I thought there was an opportunity to try and resolve this if I just could speak to the prosecutors with the judge and try to convey the message. I walked in, I had my authority. I think at that time, I didn't have the benefit of Pascal's literature. We researched on mediation and criminal law. It was an American publication. I walked in very confidently and I said in open court, in the criminal courts, that, I would like to suggest mediation. The lawyers started laughing. The judge was receptive. It was just a shock to everyone. And check this out. As soon as I was done with that case, the client dropped me because I mentioned mediation in criminal courts. It's the worst thing that you can do. And I learned my lesson. So fast forward many years later, I think, okay, so let's talk about why is it so unorthodox, unusual for us to be talking about mediation in the context of criminal law. And I think Sangeet has really nailed it. It is in relation to public policy. It is in relation to constitutionality. So the consistency, etc., is extremely important. So in the context of what I normally do, how I can relate is in relation to arbitration. Certain subject matters are not arbitrable. So when you look at mediation in criminal law, it just doesn't work. You can't have parties, convicts, accused, mediating their way out of something. So it has to be very measured. The second problem that I find is that the public prosecutors have such wide powers. Mediation really doesn't work because you just need to convince the public prosecutors. Even the judges cannot convince the public prosecutors. So why mediate before the judge? Because the prerogative of bringing an action, a charge, lies with the prosecutors. So there's no need for mediation. Why sit with a third party when I have all the powers? So these are the problems that you face every day when you start trying to pitch mediation. Okay, now let's look at what I do normally. So I do a lot of environmental matters. For example, factories, manufacturing factories, and they accidentally discharge effluent into the rivers. Then it becomes, the regulators, being the Department of Environment, would then start investigating the offense. And all environmental matters are strict liability offenses. So let's take environmental matters, for example. And I think the reason why mediation will work here is because the burden is sort of shifted in the sense that at the point of the incident, the prosecution already has a smoking gun. It's already happened. It has all the evidence. So this keeping the right to remain silent, you don't have to disclose your defense, actually doesn't quite work in environmental matters. Because the starting point is, I caught you red-handed. So there's no reason why not to disclose what you have. So when we write letters of representation, we show our defense straight away. Because we want to convince them that maybe there are other considerations to look into. So for example, I think for an environmental matter, if there was an incident, during the investigation, of course, there's no room for mediation because it's investigation, and they are investigating to charge the company and or the directors. So then where's the gap? So what we normally do is, behind the scenes, we manage the information flow from the clients to the prosecutors. Because the prosecutors has wide powers, they can ask anything or pull anyone for questioning. So we try to facilitate that investigation. Once that's done, they take anywhere between 6 months to 18 months to bring a charge. That is the window. That window where no one talks, everybody is just waiting, that is the window where we can sort of try and figure out a way to start that conversation. Normally, we can't speak to the prosecutors because that's a no-no. We have to speak to the Department of Environment, the investigation team, and they become our mouthpiece to the prosecutors. And I think that's the problem. And of course, I can understand where the prosecutors are coming from, because if you have too many conversations and no charge when there was a clear offense, then questions are going to be asked about the prosecutors. So maybe having a safe environment, a controlled environment where parties can discuss about how to deal with this incident is fruitful. Now let's take this one step further. It is not, the regulator's duty is to regulate, is to enforce the laws. But sometimes they are so focused on investigation, prosecution, and getting a conviction, they forget the bigger picture. So when we advise clients, for example, this is an actual scenario. So this client took through an M&A, bought over this company and factories, and the factories, the underground pipings and everything was completely bust. And they were spending a lot more money trying to maintain this factory. So that's the story behind. But prosecutors won't want to hear this. They just look at it and say, hey, you've already polluted the waters. 15 children got sick. Let's take this one step further. Once you start prosecuting the companies, now with the ESG laws, supply chain, reporting obligations, it's not about taking responsibility. Yes, we accept the responsibility, but once you charge and there's a criminal conviction on the company, it becomes horrific. The reporting obligations back to Europe and the consequences thereof is wide-ranging. And that messaging, we try and speak to the prosecutors about this through letters of representation. It just doesn't work because it's unrelated to the incident. But that realization, that conversation can never happen. So sometimes we try to bring in MITI, MIDA, embassy, and have a conversation, but the levels are not there. And a mediator can unlock these levels to help the prosecutors understand that you can regulate. The only way, it's not the only way of regulating by just prosecuting. There's other ways to do so. And these companies are willing to spend to upgrade their systems, to remediate the problems. But there's just no conversation. So that process, that mediation process is facilitated. And that is, I think, one area that we can look into, trying to have a safe environment where all parties are talking. Now you'll be thinking, hey, what if it's a fishing expedition and they get more information? The counter to that is, look here, it's a strict liability offense. You've got nothing to lose. Second, the public prosecutors have wide powers. If they want the information, they can get it. So why not share and discuss in an open environment? So there's no issue about fishing. The other area that I think could work is during so you have the investigation, waiting for the charge. That's one window, then the charge. Now, the charge sometimes comes with the director or directors. Now, here comes the best part. So if you are sitting in a board of directors of 5, the prosecutors will just pick 2. There is no system to this. So they can just pick 2. But the counter argument is that all directors should know their obligations when it comes to safety and environment. But the problem is, one director is in Netherlands, another one is in Switzerland, and then 3 Malaysian guys. The 3 Malaysian guys, one of it is actually an accountant. They have no idea what's going on. So you just prosecute. So having that negotiation or conversation about who to prosecute could be one of it. The other issue is, during the letter of representation, yes, you can give a lot of information in your letter of representation, but at the end of the day, it's just a piece of document. There is no way you're going to be speaking to the prosecutors in whatever way. So it's actually the same process during that time when you're going to be charged, and after you're charged during the letter of representation. That could be another window where mediation can come in. And sometimes like occupational safety, it is not a strict liability offense. It is reasonably practicable, ensuring the safety and health of its employees. Safety and health of employees in a building like this, compared to, for example, in a construction site, the prosecutors won't know, because they are looking at it completely different, and honestly, they won't have that sort of industry knowledge. Trying to impart the industry knowledge at the letter of representation stage is extremely difficult. So when you talk about safety and health under OSHA, industry knowledge, and telling them that reasonably practicable as a main contractor to take these steps is sufficient, because I've hired a specialist guy to actually carry out the works. So he should be in charge. But the prosecutors instead will just charge everybody because it's overlapping obligations. So these are the sort of conversations to be had with them. And it could be before the judge, or it could be before a specialist. And maybe we can get somewhere. And it could very well be saving a lot of time to the prosecutors in choosing what or who to prosecute.
Thank you very much, Shannon. Now I'm going to invite Sangeet to weigh in on something, and then I will have a question. Now, as you can tell, we had the framework, what is played out in Netherlands, shared with all of us this evening. And we had the perspective from Sangeet from the general criminal practice, and then a very different angle from Shannon. And I hope that you all are taking seeds from this. And Sangeet, would you like to add on to that?
Yeah, I think just picking up from what Shannon said, the AGC plays a very, very important role. And I think we have a fixation on this correlation between public order and imprisonment, put everybody into prison. And that means public order. So I think if the AGC comes on board to understand that public order is not always met by putting people in prison, and in fact, you are probably making the problem even bigger, then they would be in a position to change the narrative. And they are the ones who are in fact in control. So this is a very important conversation to have with them. Now, the public interest is not only served by putting people in prison, the public interest is served by reducing crime. Now, that can be achieved by giving people a second chance. And that's why I'd like to start with juveniles. You see, and if we ensure that they are not going into prison for the pettiest of offenses, where they're going to meet with the bigger criminals, they're going to come out with a criminal record, they're not going to be able to find employment, they're probably going to be shunned by family and friends, and then you're going to just send them back towards the doors of the prison again, you are starting the cycle, or you're just continuing that cycle. So once the AGC can understand that there are many ways to serve the public interest and to ensure public order, which doesn't always mean imprisonment and sentences to that extent, I think we are definitely there's a starter here, and we should be having these conversations. A long way to go, but certainly something to talk about.
Thank you, Sangeet, a voice of the first conversation. Now, we have just like that, an hour and more has passed, but I'm going to impose on all of you to just to stay back for a little while. I'm going to be inviting Pascal to weigh in on what he has heard for the first time, some of the challenges in the Malaysian context, and perhaps spend about 5 minutes giving his view. And if there are any questions, we will take 2 questions so that we can then wrap up this very interesting evening with that. Pascal.
If I hear all of this being said, and a lot of thoughts going through my mind, there's always one question that I ask myself. So what's the issue? Is the law the issue, or do people have an issue? The people have an issue, right? So let's start work on that first, and then see how it fits within your jurisdiction. We're still dealing with people. People with emotions, people who might have made just a mistake or did not do the right thing at that particular moment. And to what you mentioned, Sangeet, when you're looking at juveniles, we invest more and more time, and we see more and more cases of juvenile crime being referred to mediation to ensure that they will not just come back. As a matter of fact, there is a whole research being done by Jonas from the University of Maastricht, the Netherlands, where we investigated, like, okay, what's the chance of they're just going back and committing a crime again? Mediation, we've seen with mediation, it reduces by about 65% the chance that they will go back their crime. So imagine that on the impact what it would have just on the just court system, because they're not coming back. But moreover, as you mentioned, the public. We may, in that way, in a different way, we handle disputes differently, make the environment just safer. It's important to have, and that's the other thing, we need to think of end-to-end thinking, end-to-end process. In that whole chain, there are a lot of parties involved. So if we would consider to reach out to those parties which are relevant in that whole chain and start as early as possible, then we're even just better just in controlling just it. And we, of course, we need to make sure that instead of peacekeeping, which is the law and order, but going to peace building. We're building the peace. We're building peace, right? So that's what I've just, or my, one of my thoughts. The last thought, and that's that I have. The discussion that you already, each of one of you have, and just you going through your mind, that you might think like, well, nice Pascal, but I do not believe in it. Which is great, but I'm still keep in mind what I've just said. We're dealing with people.
Thank you very much, Pascal. Can I ask, Jeff, you have a question?
Okay. Does the mediated settlement agreement bind the prosecutor in Netherlands and stop the wheels of criminal justice? This is a very important consideration.
Thank you for that question. So it is a contract between the parties, so it's binding because it will be part of the court file. So if they not comply to what they've just said in the agreement, just goes back. But still, even though then there's just agreement, we need to respect our court system and the respectful just judges and the prosecutors in their just thoughts. In the end, they're just to decide, not just we. Did it answer your question? I think we just have just a minute understanding just of just in language. I'm gonna try to just be concise as I can be. The prosecutor always has a chance like, hey, this is a great agreement. I do not have to do anything in it anymore. The other option is like, it's a great agreement, yet I still feel that there needs to be just prosecuted, or it needs to be just some form of punishment. We make them just aware. People can ask like, okay, for us it's done. We do not want to just continue this whole process. They can ask for it, but they, at the same time, they realize it's up to the court, not up to them, because they cannot play for their own judge.
So ultimately, it's still back to the court again, regardless of the fact that parties have reached some version of a settlement. Okay. Any other questions? Yes, Sahin.
Hi, I have a question for Mr. Pascal. Earlier, you gave an example and you ended it by saying, we forgive you, as in the victim would say, we forgive you to the perpetrator. I suppose that is at the heart of it, really, when we go from a private dispute to criminal law. How do you deal with the idea of who is to forgive? Is it for the victim alone to forgive, or is there a public interest element here? How do you grapple with that? Where you're coming from?
Very good question. Forgiveness is the greatest good that you can give to anyone. Not everyone is just being. It cannot even just be possible to forgive someone. Again, forgiveness doesn't mean that it ends right there. For example, just in the extreme case, yeah, then you can just do anything. Yeah, and if the other party or the victim says, "No, I'll forgive you," then it stops there. It doesn't just stop there. It's more just a dialogue between the parties, between the victim and the offender, because that's where the true restoring of the relationship is happening. And everything else is just part of just procedures. So we're only looking at that like particular element of just forgiveness and restoring that relationship, and that they will feel free if they would just see each other. They run into at the grocery store, for example. That there are no just bad feelings, and it's also just being a relief. Forgiveness does a lot with the person who receives it, but even more to the person who gives it.
Thank you, Pascal. Dr. Mary?
Thank you, Shanti. The 10%, that didn't make it, I understand in the Netherlands, it's prosecution or judge that will look at suitability of cases that may be referred to mediation. The 10% that didn't make it, what's the impact being like insofar as the finality of the case, the trial? Are there any adverse or regrets? Thank you.
Thank you for that question. The 10% basically says does not come to agreement. Then it's the definition of when is a mediation successful. Maybe you already have that conversation, but you cannot just come to an agreement. So that's one thing to consider. Secondly, if for whatever reason mediation fails, we only report it back as we did not come just to an agreement. Only that, not what is being discussed, the how or the whole process, because that would breach the confidentiality. Does it have any just effect? No, I know just for in a couple of cases where the judge was really convinced, like, well, these people should mediate. Didn't work. After 5-10 minutes, it was total mayhem. Just sent back. Okay, well, that surprised me because there were such nice people. Just when I had just in the court, doesn't happen. They take it just into account, but it's not a guarantee in that sense. Did it answer your question?
Sorry, maybe I wanted, I'm thinking about mediation. It looks like I'm asking a question. When I look at mediation and the stuff that I do, it sort of fits because, and the example that Sangeet gave, juvenile offenses, I get it. But what if it's something a bit more serious? Something, an offense that really, a very serious offense. Would mediation then have a place?
Okay. I've done really severe cases. Were they successful? Yes. And they are just mediatable, but it's just about just the definition. Because you're talking about the severe cases about murder and all that stuff, right? Yeah, or yeah, corruption. I would like to just keep it just short because I believe that we should focus on what we can do right away instead of what we cannot do because we're seeing that. The only thing is what I would say, mediating murder cases is the family of the victim always have 3 questions to the offender. Why did you do it? Did he or she suffered? And the last one is, what were his or her last words? Strangely enough, it brings some sort of closure. Doesn't solve all the regret or anything, but these are the 3 questions I've seen constantly being asked towards just the offender. And sometimes it's only just looking into the eyes. Who is he? Is he a person or is he just an animal? Right? So it is possible, but it's very specific, but there has to be a lot of preparation. But there are so many cases out there which we can resolve right away. So let's focus on that and show the public, because the other thing, the audience might think like, well, it's not going to work. Show them that there's the different way.
That's working.
I think everyone's committed. Can I just check with AIAC? How long more can we, because we get 10 minutes? Oh, thank you so much, Judge. Okay, yes.
I'll try
And
to
then,
be.
yeah,
I'll try to be quick.
yes, the first question,
Does that
second,
op-
and then
sorry.
Tulasi. Yes, go ahead.
Does that still open a risk of the criminal system being hijacked? I'll give you an example. A drug dealer making lots and lots of money is firing bullets at somebody, the target. One bullet happens a lot in Europe, goes to an innocent victim, and then he offers a lot and lot of money to the parents. And isn't that a hijacking of the criminal system if there's a settlement?
Okay, so I'm just going to repeat that for those who may not have heard. Is there a possibility of hijacking the criminal system if there is mediation?
No. There's no just hijacking in that sense of that system or just abusing it. We're very aware of it, what's going on and how it's being portrayed. If it's not just sincere, if they're just like malintent, and we see just malintent, I should just mention, yep, because of money makes the world go around and everything. We are, because I've said like, hey, name your price, we'll fix it. That's not going to just, that's not going to work. Because we also need to think about the public. What would the public will be thinking? They're all just procedures. So that's a resounding no from my side.
Thank you. Can we have the gentleman over there? Yes.
I would like to raise a conceptual point. Mr. Comvalius mentions mediation in the classical sense of a mediator in the middle between 2 parties. The examples we hear from Malaysia so far, plea bargaining is between 2 parties negotiating. Likewise, in your case, Shannon, is also about 2 parties. Where is the mediator in this whole system? In Malaysia, who could we suggest to be this sort of honest broker, the mediator? I could suggest a few. For example, Suhaka may well be one of those involved in maybe human rights abuses, criminal law, and even for, say, environmental issues where a particular factory is involved. The mediator party might well be a chambers of commerce, for example, the Malaysian chambers of commerce for industry and so forth, the Federation of Malaysian Manufacturers. They might well be the best person to try to act as a mediator and say, hey, look here, you haven't thought about this. You haven't thought about the consequences on Malaysian industry if you are so strict about it. Where is this whole discussion if we don't have even an idea of who is the mediator here?
Okay, just to actually there's nothing to answer, but the 2 examples, and this is the part where I forgot. The first example I gave was more facilitative, notwithstanding that it is a party-to-party negotiation. Sometimes having a facilitator there would facilitate the communication between the parties a bit better. The second part, once the charge is brought against the accused, it becomes an evaluative mediation, because you are evaluating the case. For example, like, are you sure that you can meet that threshold? So you need a sounding board. Who better than a mediator giving an unbiased opinion, professional opinion? And the idea of who sits as a mediator is the easiest question. Trying to introduce it into the system is the biggest struggle. But once we do that, I think the who can be answered very easily.
And speaking about the who, I think Pascal, could you just spend a minute to talking about who is trained for mediation in Netherlands and how does one get trained to be a court, working with the court, not for the court, mediator?
Well, we have to jump through a lot of hoops to make sure that we just make all the credentialing, so the proper training, exams. And if you're going to do mediation just in criminal cases, well, you have to just sit in, and after only just like 10 or 15 just mediations, then you're allowed just to do it just on your own. We keep just that quality. We have a roster in that sense, and it's going to be just monitored. It's only certain list that people can do just mediations in these criminal cases.
Thank you. Tulasi, I think you had a question.
Yeah, I would like to direct this question to Sangeet, in fact, and tap on her wealth of experience in criminal practice. Forgive me if I don't use the right terms. I'm a civil practitioner. I know you limited your suggestion for early adoption of mediation in criminal matters to juvenile matters, but would you consider it for the DDA, the Dangerous Drugs Act? I think the threshold, and this is arguable, of course, but the threshold for presumed trafficking for each of the drug categories, arguably, again, is quite low in Malaysia, and some might not even constitute it doesn't even fall under the category of drugs, arguably, like cannabis, for instance. And a lot of times, I think offenders are addicts and caught up in the system. I mean, might that also be a suitable, this might be a suitable way to resolve.
Thanks for the question. I think with the Dangerous Drugs Act, it is a slightly different creature because you have two categories of offenses that you've just spoken about. One is possession and one is trafficking. The problem there is the thresholds, and that needs to be readdressed. We are talking about thresholds from 1952. A lot of drugs have changed in the manner in which they are made or the categories today. So the answer to that is revisiting thresholds, not mediation, in my view. Especially for trafficking. Now, if you're talking about possession, that is a different category. I think possession shouldn't even be going through criminal justice system to begin with. And in fact, we are proposing a different avenue for that altogether. But in the meanwhile, perhaps mediation is the answer. But we go back to the constitutional issue because you have statutorily provided for sentences within the DDA for your Section 6 or your Section 12 possessions. And the courts, we are still bound by that. So unless we address the constitutional point, it's going to be very difficult to mediate out of it because you will have a situation of bargaining your way out of a criminal offense, which is a problem. So for the DDA is a different answer. It's a totally different route for users and a totally different issue with traffickers.
Or we could legalize some drugs like in Netherlands.
All right. So now yes, Jeff. Okay, we got Jeff and then one more person. Are there prosecution officers here? Okay. All right. Thanks for that, Jeff. I'm just going to hold that question. Can we ask the young lady over there?
I have a question for Mr. Pascal. I wanted to know if there are many instances of going for mediation in non-consensual dissemination of intimate images or any other online gender-based violence cases? And if it is it effective?
Yes and yes. I'm happy to answer, just elaborate more towards your question, but yes.
Yes. Okay. On that, yes. Now, this was a vibrant session. Now, Jeff has thrown a gauntlet to the panel to ask what is possible. And I think I'm just going to try and summarize it. If I leave anything out, my panel will correct me. Pascal has put before us the opportunity that, or rather a framework that provides us an opportunity to think about the possibility of mediation in criminal cases. We've heard the challenges from both Sangeet and Shannon. But what I'm hearing from Sangeet is that perhaps the low-hanging fruit will be the juvenile cases because we need to start somewhere. And from Shannon, perhaps 8 years later, you will not be dropped by a client if you were to suggest mediation in some of the environmental or OSHA cases.
I think for me, any statutory body, regulatory bodies, I think there's an opportunity, except for MECC. MC maybe a bit difficult, but there's a number of bodies, statutory bodies. I think there should be.
And that's where we are. At the end of this,
sorry, one second. For example, in Malaysian, what used to be MAFCOM had a inbuilt mediation, statutory mediation dispute mechanism. That is what we should be looking at. Something within the system that helps facilitate problems, specific industry problems. Securities Commission.
And the ideas keep coming. And that's exactly what this evening talk has achieved its goal, to start the conversation. And that's only a start. So I really, firstly, I think from the perspective of the panel here, this is an amazing full room still at 7:30 in the evening. So I want to just first thank AIAC, Danish, and Dato Mary and the team from AIAC for pulling together this evening talk series at short notice. Thank you all for taking the time to be here this evening. It is such a privilege and a pleasure to have hosted Pascal Comvalius, Sangeet Kaur, and Shannon Rajan. Can you please give my panel this wonderful round of applause?
Thank you everyone for joining us today. And we would also like to thank Ms. Shanti for very effectively moderating this session and all the other members of our panel. I would now like to invite Dato Mary to present a small token of appreciation to the panelists.
Which one? I start with Shanti. Without you, we couldn't have done it. I come to the front. Okay. The photographer has got a place. Okay.
I would now like to invite Mr. Pascal to come forward. I request Ms. Sangeeta to please come forward. Sangeet, sorry. And Mr. Shannon as well. Thank you, everyone. This brings our session to a close, and we invite everybody to join us for the network, for a group photo followed by a networking session outside. Thank you.